keep in mind also the reason that uh, knowing the facts is so important. A case's usefulness as a precedent in a future controversy will depend on its similarity to that controversy. More on that in chapter 3. Law school law school exams test your ability not only to recognize cases that appear relevant to a particular factual situation, but how strongly they apply to the given facts. When you emerge into the real world of lawyering, your power to advocate a legal position effectively will depend strongly on your facility with cases. The version of the facts that a court accepts for purposes of its opinion can depend on how the case got to that court. For example, say a defendant moves to dismiss for failure to state a claim. In other words, he contends that the plaintiff does not have a case. The court will consider, for the sake of argument, the facts as asserted by the plaintiff in order to assess whether she has any chance at all of presenting a winning case at trial. The Guilford case, the Guilford court stated its was intention to view the facts in the light most favorable to the plaintiff, so that when it slammed Yale, it did so without appearing to have jumped to any unfair conclusions. After trial, however, an appeals court will accept the lower court's version of the facts rather than one of the parties' accounts. This is because both sides have already been given the opportunity to be heard. Fairness, therefore, does not demand deference to the loser's story. The court can then avoid dabbling with the facts and concentrate on pure questions of law. Although uncovering the important facts of a case is a skill that develops with experience, several avenues of general inquiry often provide worthwhile starting points. Number one, parties. Who are they? If they are more than one on either side, what characteristics and interests do they share? What are the relationships among co-parties and between opponents? Are any special duties or obligations attached to these relationships? In the Guilford case, Dudley had been invited to the reunion by the Yale administration, who hoped both to elevate his spirits and loosen his wallet. As such, the court considered him a business invitee to whom Yale owed a higher degree of care than it would to an uninvited visitor. Two, places. Is there a geographical location relevant to the lawsuit? For example, does it matter that the parties are from the same or different city, state, or country? Three, events. What is the transaction or occurrence that resulted in the lawsuit? What details, if changed, would alter the tenor of the claim?